What I want to do in this lesson is talk about our understanding of human rights and civil liberties within the United Kingdom. And this is going to relate specifically to the nature and sources of the British Constitution. Because essentially, when we think about one of the key fundamental aspects of constitutional law, we are focusing on this idea of a relationship between the state and the people. And one of the ways in which this relationship exhibits itself is through the idea of civil liberties and human rights. So that's why that's an important part of this particular series of lessons. Now, we're going to explore some of the constitutional implications which are related to fundamental rights and specifically talking about this idea of civil liberties. Now, there is a lot of philosophy that is spent talking about and trying to make a delineation between the idea of human rights and civil liberties. Essentially, I'm just going to be using the two interchangeably in this lesson. Okay? So, the concept of human rights attempts to identify fundamental human interests which have some kind of special status in the sense that they are not to be violated. Now, if we go to the codified system in the United States and we look at the way in which the the US's codified constitution operates, they also have a collection of what are described as fundamental human rights that are codified in the Bill of Rights and even in some of the amendments that are after the Bill of Rights. Now, one of the things that is interesting here is that essentially what the concept of human rights does is recognize that there are some fundamental characteristics that are applicable to every single human being, regardless of where you are from and regardless of whereabouts on the socioeconomic ladder you may be, your ethnicity, your race, your gender, your sexual orientation, etc., 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 and that these rights ought not be violated. And in doing so, this provides a very useful protection of individuals against the arbitrary will and the arbitrary discretion of the state. Now, there is no agreement as to how we identify these human rights, whether or not we should classify some human rights as being more applicable than others, what fundamentally makes a human right. There is some philosophical literature that debates that as well. So on the one hand, like I've said, there is just the idea of human rights just are these fundamental inalienable characteristics, whereas other people maybe justify the existence of human rights on different grounds. So maybe for practical reasons, it might be a useful tool to be able to apply the language of human rights. Some use it on a justice-based reason, saying that the rhetoric and the language of human rights is a precise tool for the implementation and the perpetuation of justice. That is an argument that's presented by Finnis in the 1980s. Now, some claim that human rights are revealed by God. Others say that they just come out of this idea of human beings having some kind of special dignity. So, in terms of the philosophy of human rights, that is a university module all in itself, never mind an A-level syllabus topic. So we're going to move swiftly on and talk about how human rights is operated and operationalized in the United Kingdom's constitutional framework. And the starting point that we really should look at there is to look at the European Convention on Human Rights. Under the UK Constitution, the ECHR, the European Convention on Human Rights, has three distinct roles. We, as a United Kingdom, signed and ratified the European Convention on Human Rights when it was created back or as far back as the 1950s, and have been members ever since. Be sure to check the time when this lesson was uploaded, because in a few years' time this might be outdated, given the fact that a lot of the rhetoric of the Conservative government at the moment is centred around us leaving the European Convention on Human Rights. But under the UK's constitutional framework, the ECHR has three distinct roles. On the one hand, an individual can petition to the ECTHR, should I say, the European Court of Human Rights in Strasbourg, alleging that the state, i.e. the United Kingdom, has violated their individual rights under the Constitution. The European Court of Human Rights then may award compensation or require the state to change their law or whatever in that regard, and therefore make a claim that they have violated the ECHR. Equally, the ECHR can say that actually your rights haven't been violated, and that would be a case where they side with the state. The second role is that the decisions of the ECHR are binding only in international law, and they so therefore have no direct effect in domestic law. So one of the things you might notice is if you look at the first point, it says here that the court may award compensation or require a state to change their laws. You might firstly look at that and go, well, doesn't that contradict the fundamental principle of parliamentary sovereignty? Now, the answer to that question is no, because that court ruling will be applicable within international law, and therefore would not be binding domestically directly onto the UK's parliamentary system. And then finally, unlike the European Union's Court of Justice, where decisions are binding at the domestic level, the ECHR decisions that are brought down by the European Court of Human Rights are binding at an international level. So as a treaty, the convention should be taken into account by domestic courts when interpreting statutes. So when we look at when statutes are created by Parliament, they do take into account the Convention on Human Rights, but they do so out of a political obligation and not out of a legal obligation, again, because Parliament is legally sovereign to do whatever it so chooses. It is also argued that the common law should be developed and reformed in light of the convention coming into effect. And this was taken into account in a particular case here, the Attorney General and Guardian Newspapers Limited case from 1998. But what is more important, specifically to the UK constitutional framework, is less about the European Convention on Human Rights, more so the Human Rights Act from 1998. Because what the Human Rights Act of 1998 does is incorporates the main rights that are listed in the Convention, not necessarily the Convention itself, but the main rights that are listed in the Convention, into UK domestic law and provides a special mechanism for applying them within the domestic court structure. Essentially, what happened before the passage of the Human Rights Act and the coming into force of the Human Rights Act was that if you felt that your convention rights had been violated in the United Kingdom, you would have to take that grievance to Strasbourg. You'd have to take that grievance to the European Court of Human Rights. What the Human Rights Act did was incorporate them into the domestic legal framework of the UK's constitution. So whereas the European Court of Human Rights decisions were binding in international law on the United Kingdom, the Human Rights Act-based decisions are binding in domestic law by the UK's domestic courts. In R and Secretary of State from 2007, Lord Bingham points out that rights under the Convention differ from the rights created by the Human Rights Act by reference to the Convention. So there's a little bit of a legal terminology and legal rhetoric that needs to be quite carefully walked through, shall we say, when we talk about the distinctions and delineations between the European Convention on Human Rights and the Human Rights Act. Because the Human Rights Act, essentially, if we were being colloquial and we're just talking about this broadly, you would be remiss in saying that the Human Rights Act actually just incorporates the convention into UK law, and it does to an extent, but Lord Bingham points out that there are certain differences and certain delineations that you can make between the Human Rights Act and the convention rights that are established. As we've said already, the Human Rights Act does not incorporate the European Convention of Human Rights into UK law, but rather gives rights to incorporates rights into UK law that are drawn from the European Convention on Human Rights. All legislation must be interpreted in accordance with the Convention rights, and the Act provides remedies enforceable in the courts against public authorities who violates these rights. The Act does not provide an override to parliamentary sovereignty. And why is that the case? Well, because there is no special entrenchment that the Human Rights Act has in law. There's no special entrenchment that says that future parliaments cannot repeal the Human Rights Act. So if a future parliament in 5 years' time decides that they want to repeal the Human Rights Act, and they have the majority to do so, then they have all the power and all the authority to do so, and could just as easily do so as they could right now. The thing that keeps the Human Rights Act in force to this day is a collective belief in the Human Rights Act and a collective limitation on the political sovereignty that is had by Parliament itself. If it became politically popular to reverse the Human Rights Act, then potentially this might be done by a government that comes in, that wins on a manifesto, that repeals the Human Rights Act. So it doesn't provide an override to parliamentary sovereignty. Parliament chooses to act in accordance with the Human Rights Act, therefore limiting its ability to create legislation which contradicts the Human Rights Act. And then finally, the thing that we ought to note is that Article 1 or Article 13, those are both part of the European Convention on Human Rights, but they are not included in the Human Rights Act itself. It applies to all legislation, whether made before or after the entering into force of the Human Rights Act, which means that it has a certain amount of retroactive authority. So if a piece of legislation was passed in the 1970s which contradicts the Human Rights Act, then a court may be able to conclude that the previous legislation is incompatible with the Human Rights Act itself. So that, given the sort of technical details of the Human Rights Act, and I understand that it is technical and it is something that even law students in their second and third years at university studying human rights law, either European or UK-based human rights law, struggle to deal with some of this content. So don't feel so overwhelmed if you feel like you don't understand this content. Given that we've dealt with the technicalities of the Human Rights Act and the ECHR, let's think about the principles of the Human Rights Act. So where primary legislation, i.e. parliamentary legislation, is incompatible with the Human Rights Act, the court can draw attention to violations by making something known as a declaration of incompatibility. Now, where there is a passage of legislation into law, within either the first or second reading, they have to make it clear that the piece of legislation, the bill that is being proposed, has to be in accordance with and compatible with the Human Rights Act. There is also what is known as a fast-track procedure, which is available in special circumstances, and what it does is enables amendments to legislation to be made in order to ensure that any potentially incompatible elements of that legislation can be made compatible with the Human Rights Act. The Human Rights Act can also be directly enforced against public authorities and by a victim defined in accordance with the case law of the European Court on Human Rights. So where we have mentioned, and where Lord Bingham mentions in the previous case from 2007, that the Human Rights Act you should delineate the rights that are enshrined by the Human Rights Act from the rights that are enshrined by the European Convention on Human Rights, and note that the Human Rights Act takes rights that are drawn from the Convention. It should also be noted that public courts in the United Kingdom have taken decisions and precedent from the European Court into consideration when making their own considerations relating to human rights in the United Kingdom. As we've already said as well, the Human Rights Act does not include any provisions which overrides parliamentary sovereignty. And what this does is, as I've mentioned previously, make a distinction between what we would describe as the political sovereignty of Parliament and the legal sovereignty of Parliament. Parliament would be perfectly within its legal authority to override at any point the Human Rights Act and pass legislation which is incompatible with it. Now, the question of whether or not you can override the Human Rights Act by way of the doctrine of implied repeal, which is something that we've noted previously in earlier lessons on parliamentary sovereignty, is one that is a constitutional question that is sort of thrown out into the ether. You have the case of Thoburn and Sunderland City Council, which sort of implies that you could not do such a thing. But does that imply that parliamentary sovereignty is limited in that regard? Or does the doctrine of implied repeal even fall under the main umbrella of parliamentary sovereignty? That's a question that has to be asked and might potentially be asked in the future. But in terms of the legal authority to override the Human Rights Act, that is perfectly within the remit of Parliament. Of course, this would therefore have potentially dire political consequences, and so for the most part Parliament has kept in line with the Human Rights Act's political authority. And one of the things that is noted that is where courts have said that there are pieces of parliamentary legislation that are incompatible with the Human Rights Act, and that they should change that piece of legislation, Parliament has, for the most part, gone along with the court's rulings, even though legally they don't have to. So we have a lot of back and forth and argument to be had around the Human Rights Act. And for the most part, it is often the case that it is public policy and governmental decisions that also find themselves in the Supreme Court looking at Human Rights Act decisions. So the Human Rights Act is a very interesting and potentially controversial in some elements, in some areas, piece of legislation that is very useful for both incorporating or at least drawing from European Convention rights, and also talking about the debate between the limitations on parliamentary sovereignty versus the realities of legal parliamentary sovereignty as well.